before Daphne makes talks for both of us, because she speaks much better English than me, I want to talk about Frank Bisbee and his enthusiastic ideas about Spain. He used to go to Spain with his students for collecting plants, and he always remembered with special warmth the starry nights in the mountains collecting plants, the wine, and the good food. I'm going to be here your bodyguard.
Okay, you're my bodyguard. Okay. So Miguel and I are going to be talking about a way that may help with this plethora of names that we have, the list of available names, which may provide a new way to develop a stable nomenclature. Miguel and I are both commissioners of the International Commission of Zoological Nomenclature, and we both work at museums. I work on sea anemones. Miguel works on weevils, and therefore we cover the entire globe, land and sea. Now, Article 79, that is the subject of our presentation, is entitled The List of Available Names in Zoology. And it outlines a procedure that I'll go over not in detail for assessing the list of available names by simultaneously adding to the LAN a large number of names as a part of the list. Now, prior to this, of course, there were articles numbered 79, but this particular one appeared first in the 4th edition of the code, which we all know took effect the 1st of January 2000. In the previous versions, the Article 79 had to do with plenary power. In edition 3, it was called powers. Our power has diminished over the years. In Article 2, that article, in edition 2, that article was only half a page, but by edition 3, it was 2 pages, so even though our powers have dissipated, it's taken longer to say so, I think. So the reason we are making this presentation is that Miguel is the chair of a standing committee on how to implement Article 79, and I am chair of an ad hoc committee that is currently handling one of the appeals to the Commission to provide a part of the list of available names. And we're here today jointly to announce the procedure that our committees have decided on to be proposed to the Commission to announce to the community how to go about adding a part to the list of available names. Now, this is a very important step, and it's taken us quite a long time to arrive at it, because Article 80.5 of the code says that when the Commission makes a ruling on an appeal, on a case, that decision applies only to that case. It's completely particular to that instance, and no conclusions other than those expressly specified are to be drawn from it. So it is not generalizable. We are not setting precedent in the rulings, unlike, for example, the United States Supreme Court, in which a ruling in one case then can be used as precedent to infer what the ruling will be in a similar case. However, for the case of Article 79, we are setting precedent. So we wanted to make sure that the procedure that was outlined by the standing committee then could be implemented for every proposal that comes forward under Article 79. And of course, now this feature has gained importance with the development of Zoobank, because the list of available names can be an important way to get names into Zoobank, and not only names into Zoobank, but those that have been certified by the Commission. Because one of the things we hear a lot about Zoobank is, how do we know that they are correct? And these will be nomenclaturally certified. So we potentially have a way to get a lot of names into Zoobank. Now, I want to point out some things that Article 79 is not. And it doesn't involve this book and its subsequent online version, the official lists and indexes of names and works in zoology, because in there, names are added to the list one by one, or at most in small numbers. But the list of available names is compiled by large numbers at once. And the code is very clear on this. If there's a conflict between the two, if something is listed on the official list and it is contradicted on the list of available names, the list of available names takes priority. So it supersedes any ruling or opinion that has been rendered that has gotten a name onto the list. So it's important that we do this thing right. So Article 79 is quite long. It outlines a procedure of who may propose, and unlike Sherborn, it requires that a group of people have decided on a list of names. Individuals may not propose parts of the list. And it outlines the role of the commission. It outlines the form of the proposal, what the proposing group must do, what can be on it, what the commission is to do when a candidate part is submitted, and what the commission is to do with the candidate part. All of this is outlined in, may I say, excruciating detail in the code. And it has a lot to say about timing. So once the candidate part has been submitted to the commission, notice is published that it's open for comment. And the list will be put up on the website of the ICZN, and the public then has 12 months to comment on it. At least 2 years after the comment period was open, that is, another year after the comment period is closed, the ad hoc committee, and I chair one right now, that is responsible for this can ask the commission to either recommend the proposal be abandoned entirely or to consider a revised proposal. Note that one of the options is not to accept the part as it was submitted. So we can't do that. That's too easy. So it has a lot more to say about timing. Then the revised list, if it is recommended to be reconsidered, the revised list, that is the list changed in response to the comments that were submitted in the first year, have to go up. The community has another year to comment on it. And then after another year of discussion by the commission, it can vote either, again, to abandon the proposal, or this time it can vote to adopt the part and put it on the list of available names. So we have a minimum of 4 years consideration time after a committee of experts on the subject of the part, and that is for a particular taxon at a particular rank and for a particular time period, has proposed it to the commission. So Article 79 describes a type of application to the commission. It outlines who may submit a proposal. It outlines the form of the proposal, the role of the commission in responding to the proposal and of the community in commenting on it, the timing, but it doesn't say what's supposed to be on the proposed part of the list. And that is what we've spent a lot of time in the last year or so discussing in the commission. It does say, though, something about what is not on the list. No unlisted name, so no name that we don't accept to put on the list within the scope, that is the taxonomic field, the ranks, and the time period covered, of an adopted part of the list, has any status. So those names are as if they never existed. So any name that is not on the adopted part of the list has no status. And so this clearly prevents nomenclatural archaeology. any name that is not on the list that is subsequently discovered just doesn't compete for priority. It doesn't exist nomenclaturally, even though it might have been proposed according to the rules and so forth that might have been considered available. It no longer has any status. So that's one small effect of Article 79. But is that all that was proposed by the framers? So we can visualize the names that are out there, and we've been talking about that all day. So there are all the names, which is the large dark circle. And we know that there are common names, there are manuscript names, there are names that are unavailable for other reasons. So there are a whole bunch of names outside the smaller set of available names. But nomenclaturally available names are a subset of all names. And the list of available names, some people on the commission have argued, is documenting all the available names. It says so right there, list of available names. So that would mean that a list of available names would contain all the available names in that intermediate circle. And if that were what is to go on the list of available names, this would strictly be a nomenclatural exercise. It would be a bibliographic chase. We would be just trying to document what essentially we know and we've heard all day is increasingly easy to discover. The alternative that some people on the commission have argued that this very elaborate procedure was designed for is to put on the list only those names, the subset of all the names that exist and are available, that we can be certain about. It's a way to pare down and to start over again. And in this case, there's a taxonomic component to the exercise. I diverge here a little bit to quote one of my colleagues from the University of Kansas, Charles Michener, who was quoted by Stephen Jay Gould in Bully for Brontosaurus to the effect that in other sciences we can ignore the idiots, but in taxonomy we have to keep citing. I'm not sure he said idiots, I just put that up. I asked Mitch what the source of this quote was, and he said, well, he actually doesn't recall ever having published it. It's just that Gould must have been in the audience when he gave a talk one time and wrote it down, and so I can be free with my interpretation of the terms that he used. So, what did Article 79 envision? What did the framers of Article 79 have in mind by developing this very elaborate procedure? So we all know about this attic full of names. We've been hearing about them all day, that there are more generic names than there are specific names, that there are only 45% of names that can be traced to something real, and so forth. And we can keep hauling these names around. And if we do, we risk a type 1 error, which is we keep a name that we will never understand, or we can never relate to anything real. Or we can risk a type 2 error, which is that we get rid of names by this process of paring down that might refer to something real that will require us to describe that entity again. And so we're left with this choice. And we've been spending a lot of time in the commission debating, and we have commissioners on both ends who say we have to keep them all, no, we've got to pare it down to the bare essentials. If we keep all the names, in case one might refer to an animal we will someday find or understand, but the name is so unclear that this group of experts hasn't been able to figure out what it means, and 2 years of public scrutiny haven't been able to figure out what it means, but someday we discover what it means, we're going to have to redescribe it, recircumscribe it, retypify it. We've got a lot of work ahead of us to define what we meant by that name, or we can discard names, and if we discover that that name did apply to something real, we have to redescribe it. And so just pragmatically, it seems that this latter is much less effort and burden on the community than the former, with carrying around all those names of uncertain reference. So we are here to announce that the lengthy and exhaustive, not to say exhausting procedure in 79 has the intent of paring away names, so it becomes the exercise the microbiologists went through that took effect on the 1st of January 1980, so that the names that were on the approved microbiological list were those that were both nomenclaturally available and taxonomically recognizable. But this very lengthy procedure also ensures that a candidate has been thoroughly vetted, so we don't inadvertently throw out a lot of good names. So this will create a definitive nomenclature, a sort of a new 0 point, a new Linnaeus, if you will, for a portion of the taxonomic spectrum. And the implementation that we're here to announce today is that a manual that is now in its final stages of approval by the Council of the Commission is to decide that a candidate part of the land should be submitted by a group, but in addition, the group has to identify what names it doesn't want to end up on the land, so that we know they didn't overlook it, they didn't forget, they were not unaware of those names. So they've got to present all the available names, but they have to tell us which they want to end up on the list of available names and which they see as important to discard. And then the ones that do not end up on the land within the parameters of the part lose nomenclatural standing. So this procedure, with examples, is documented in a manual that will soon be available on the website of the ICZN, and any group of people that wants to present a list for consideration as a part of the land should follow its procedures, which will fill in the gaps that Article 79 has. And as I said, the manual will be on the ICZN website. So I want to thank you, and I also want very much to thank the members of the committee that Miguel has headed and the committee that I have headed, because we've spent a lot of time debating these issues. Thanks.
Thank you.